The Mascot Towers saga continues. Let's have a look. Hello everyone, Florian here, and welcome to another episode of HeiseSays. Grab your stein of coffee. Let's have a look at this article or blog post from a legal firm discussing a recent Supreme Court decision about Mascot Towers, or about the strata. Now, before we have a look at that, let me just bring up this little Google Earth Pro image so we can see Mascot Towers. Now, this entire complex has been evacuated. It was just after Opal. There were construction issues and people couldn't live there. They couldn't live there. Let's have a look at it now. We've covered this on the channel for years now. For years. And you can see last images on Google Earth. It's hoarded up, dilapidated. I mean, people bought in to this, bought an apartment in, and I don't know what's going on there. Bought in and then could never live in it. People wanted to retire in it and couldn't live in it. They wanted to try and sell the whole complex. Didn't happen. Now they've tried to, I think, wind up the strata, and the Supreme Court will have to read through a decision here. Said, looks like it couldn't happen. So, jump here. There you go. So this is really a sad situation to be in for these people. It's... How many years has this been going on? Guys, this has been going on forever. And it's just sitting there empty. It's just sitting there empty. So let's have a look at this article, guys. And we've got an extensive playlist on the channel if you want to have a look. We even went through the dilapidation report that the neighboring developer did on Mascot Towers. We've gone through this a lot, so that's kind of why I'm following the story. So the Mascot Towers termination of a strata scheme and priority in strata lending. So, in brief, a recent landmark decision, the New South Wales Supreme Court refused an application to terminate the strata scheme of the beleaguered Mascot Towers complex. Mascot Towers has been in the news since 2019, when structural issues in the building were first discovered and engineers declared it unfit for habitation. The residents were moved out of the building and have not been able to return since. Only a few businesses trading from shops on the ground floor have been able to operate in the meantime, while the owners' corporation discuss what to do, and the rectification costs just kept getting more expensive. It was a fortune back then. With the recent construction sector issues, it get even more expensive. After 3 years, the owners' corporation elected to proceed with an application to terminate the strata scheme itself under Part 9 of the Strata Schemes Development Act 2015, SSDA, and then sell the building as a single lot to a developer rather than proceeding with a collective sale. An application was filed in the Supreme Court in May 2022 for the necessary orders. The principal defendants to the application was Lanark Capital II Proprietary Limited, a strata financier who sought to protect its position as a significant creditor of the owners' corporation. Other defendants included all four major banks, other financiers, an individual lot owner, and one of the remaining commercial tenants. Termination of a strata scheme. I mean, this is why I've developed my fear of ever buying in one of these things, following the news on all of this, how bad it can get. Termination of a strata scheme is a step which has only been taken a handful of times since strata schemes first came to existence in New South Wales. In each case, there's been some supervening factor which rendered the strata scheme no longer necessary. In Pripo Proprietary Limited versus Wilbury Municipal Council 886, a single owner owned all four lots in the strata scheme and was therefore the only member of the owners' corporation. He successfully applied for the court for orders terminating the strata scheme. In owners of Agroski Court Strata Plan 21513 versus Wise, a tropical cyclone damaged all 12 units which were part of a strata plan, which were then removed, leaving the site vacant. The court deemed the strata plan no longer be necessary in that case. The process for conducting termination is set out in Part 9 of the SSDA and involves the dissolution of all lots in the strata scheme back into a single title which vests in the owner's corporation. The proposed orders in the case of Mascot Towers were that this process should be conducted under the auspice of a liquidator who would sell the building, pay off the debts of the strata, and distribute any leftover funds among the owners in proportion to their unit entitlement in the former strata. Oh, this shit. Imagine going through this. They're going to liquidate it. And these guys owe a lot of money now because they've had to borrow money for all, even the investigations and the temporary works. They would have years of props and equipment there holding up the oh. The contentious issue was in how the distribution was to be carried out and in what order. The majority of the defendants, with the exception of Lanark, did not oppose the making of the termination order itself, only seeking to ensure their interests were preserved through the process. Lanark argued that a collective sale under Part 10 was the more appropriate course, and that in any event the repair of the building remained a viable prospect. Alternatively, Lanark argued if the strata was to be terminated, then it, as the direct creditor of the owners' corporation itself, should have priority in payment of debt to it from the sale proceeds of the building before any distribution to the individual owners. Oh, these people are just... Look at... Oh. Debt. The debtor is slave to the lender. It shows you here. You know, Ramsey's right. This position caused friction with the banks and other lenders who were also defendants and had security in the form of mortgages over individual lots in the building. These lots will be dissolved as part of the termination order, and their owners' rights and obligations, including the mortgages, would transfer onto this single lot after termination. The proper order for payment of debts, they argued, was for secured creditors like them to rank in priority to an unsecured creditor such as Lanark, which was unsecured owing to the operation of Section 100 of the Strata Schemes Management Act. See, this is the lenders fighting over this bloody carcass of a project, and the people who bought the bloody units, they're right on the bottom of the list. Bloody hell, this is horrible. I was listening to there was one lawyer trying to get government involvement, and he invited me in to listen to his presentation to all the owners, and just seeing these people in tears and the shit they were going through. This is a nightmare. So, which was unsecured. Yeah. The SSMA, which allows an owner's corporation to borrow but not to secure any debt over the common property. Lanark's argument was that payment of mortgages first for the proceeds of sale would result in those owners without mortgages subsidizing those with mortgages, while the banks argued that paying Lanark first would mean that it had on termination a greater level of security and priority than it held prior to termination. The principal cause for concern amongst all parties was that it was anticipated that the proceeds of sale of the building would not be sufficient to discharge all of the debts. Yeah, this is the reality of the situation here. The owners were likely to end up with nothing, and even amongst the lenders, whoever ranked lower in priority was likely to be left tens of millions of dollars out of pocket. Just think about the stresses and pressures you've got going. You know, I know there are a lot of small business owners that watch the channel. Compare that, just, you know, the shit you've got going on, you're under stress and pressure, and I've got to make this, got to sort this, do this. Compare that to this. Imagine living through this for years. Shit, this is a nightmare. This is a complete and utter nightmare. These poor people. You can't even just walk away. You can't go, fuck it, I'm gone. Oh, this is horrible. This is horrible. This was also the concern of the owners and the owners' corporation and their reason for seeking the termination order. However, it became apparent during the hearing that at least some of the owners did not understand the effect of the termination order and expected it would relieve the owners of their burden of debt and allow them to move on with their lives. No, they're still screwed. Shit, they're gonna have to declare bankrupt. You're still gonna have the mortgage, aren't you? It's still gonna be linked to you. The termination process was likened to the winding up of a company in which a liquidator was appointed, and assets were sold, and as such the liabilities were paid, as could be with the remaining funds, with the lowest ranking creditor having to accept cents on the dollar in payment of the debts. That is the process for winding up a limited liability company. Unfortunately, as Her Honor pointed out, a strata owners corporation is not a limited liability company. Oh shit, they told him a different story. The operation of Section 81.4 of the SSMA is such that an owners corporation is required to continue to issue levies upon the owners until such time as it has sufficient funds to meet its expenses. Oh shit. Imagine buying an apartment and it's what's going to send you bankrupt. Oh. See, this is why you don't need to cover the fake doomer bullshit news that everyone's rambling on about how the world's coming to an end. There's enough horrible shit like this going on in the suburbs of Sydney. An owners corporation is therefore an unlimited liability entity to the extent that its owners are liable for the full extent of its obligations, and their liability is not limited to the value of their lots. Shit. Are you going to buy a unit now, guys? Let me know in the comments below, because this has scared the shit out of me ever buying a unit. So the outcome. In circumstances where not all owners had voted for termination in the first place, and where the evidence before the court indicated that the building could be repaired more cheaply than initially estimated. Okay, hopefully that's true. Maybe prices have come down since the pandemic. Her Honor took the view that a termination order was not the most appropriate cause, declining to make the termination order, rendering the payment priority dispute between Lanark and the banks no longer relevant, but given that the outcome of the dispute would have significant impact on the mortgage and strata lending industries, Justice Pendant elected to determine the dispute as well. Okay. Her Honor found that the proper order of priority was for the proceeds of sale to be called in and then to be divided among the owners in accordance with their unit entitlements. From those allocated funds, any secured creditors of each owner, such as a bank, should be paid first. Okay, so this is a judge that is being sensible. Most of them actually are. In this way, individual owners without mortgages were not made to effectively subsidize those with mortgages, as the division of funds took place first. The owners were then still collectively liable for any debts of the owners' corporation, such as the one to Lanark, which could be the subject of levies to be paid equally by all owners. So you're kind of screwed. So this works in the bank's favor, but it makes sense. Key takeaways. This is more scary than other news I've been reading, guys. With the termination application dismissed, the fate of Mascot Towers remains uncertain, but the owners' corporation is now armed with a better understanding of its position and with new information about the cost of repair, and should be better placed to resolve the situation going forward. The strata lending and mortgage industries have also had their relationship clarified in the event of a similar situation should arise in the future. The case illustrates the need for experienced legal advice at an early stage of any discussion on complex strata issues. Should you find yourself in such a situation, please contact our team at the earliest convenience. And this commentary was published by Colin Biggs and Paisley for general information only. And I guess, let's give them a shout out. They bloody well deserve it for this. Here you go. Contact Leanne or Richard at Colin Biggers and Paisley. Hashtag not sponsored, but this scared the shit out of me reading through this, guys. Good on them for putting out this commentary. This is a lesson for many people to learn from. Well, let's have a bit of a chat, eh? So, the Mascot Towers saga is still continuing. This seems like a nightmare for all of the owners. Now, don't get me wrong, I've been through tough times through my life, financially, with business. There have been challenges. But shit, this one scares the hell out of me more than anything. Could you imagine this being trapped in here? Hopefully, they can repair the damage to the building and get something back. Even if you could live in there, would you want to? Would anyone buy there? There's going to be a constant stigma attached to the building, even if they repair it. I'm sure eventually people would. Hopefully it can be resolved. And we'll keep an eye on the news to see what comes out there. Let me know if you find anything. And if an owner happens to watch this video, I'm really sorry. Take care. I'll see you next time. Bye for now.